Meanwhile, Senior Counsel Professor Githu Muigai and Kamau Karori have termed as unfair accusations that Independent Electoral and Boundaries Commission Chairperson Wafula Chebukati contravened the Constitution by declaring William Ruto as President-elect on August 15, 2022. The two who are representing Chebukati and the IEBC also faulted the petitioners for alleging electoral malpractice in polls, saying their arguments are speculative and lack substantial evidence.
Madam Chief Justice and the Honorable learned members of the court,
former Attorney General Professor Githu Muigai led the legal team representing Independent Electoral and Boundaries Commission and its chairperson Wafula Chebukati. Professor Muigai faulting the first petitioners called for nullification of the presidential election results on the basis of flawed verification and tallying.
There are no less than 3 governors addressing you elected under this election. There are no less than 4 senators elected under this election. And there are no less than 4 members of parliament elected under this election. When, my lords, it is not in my place to suggest the questions you should put to counsel, but I would plead with you to put that question to counsel when they return to the podium. Are they happy with their own election? If they are, how then is it that this election is irredeemably flawed?
Professor Muigai further terming the petitions by 4 dissenting IEBC commissioners as a witch hunt and the attack on the chairperson as personalized and vindictive. The former Attorney General further alleged the commission was united until the 11th hour, alluding there were external efforts to ensure no declaration was made.
The vilification against this gentleman goes beyond anything we have ever had before in this courthouse. It was personalized. It intended to lower his standing in our community and within the legal profession. It was unwarranted. There is nothing wrong with IEBC. There is nothing wrong with Wafula Chebukati. There is something very wrong. There is something very wrong in the way the persons who participate in the electoral process accept winning or losing. That's the problem.
His sentiments were echoed by lawyer Kamau Karori, who, in responding to a question on interpretation of Article 138 of the Constitution, termed submissions by the petitioner's legal team as motivated by lack of understanding of the electoral body's mandate.
The court at paragraph 287 says the duty to verify in Article 138, which I've just referred to, is placed squarely upon the Independent Electoral and Boundaries Commission, which was the first respondent. It is exercised by the various agents or officers of the first respondent. That is to say, the presiding officer at a polling station, the returning officer at the constituency level, and the chair at the National Tallying Center. No reference here to members of the commission. And this is very deliberate. The process of conducting an election is a statutory process. It is set out in statute. It is not an issue that is left to determination by the commissioners in a meeting of plenary as they have suggested.
Professor Muigai and Karori calling for the dismissal of the petitions on the basis of unsubstantiated evidence. Yusufar reporting for Prime Edition.